Good morning. My name is David Gittins. I'm going to be the moderator for this panel. And we have three persons here with different experiences who will be able to help us discuss the topic of the securing the Barbados digital infrastructure. Is the Data Protection Act enough? Now, as we would have known and we would have heard in previous discussions, we recently passed the Data Protection Act, which deals with the privacy of persons' information. It is not proclaimed, but the act has been passed in the House, and it will eventually be proclaimed. So we are looking at, is the act really enough to protect Barbados, or do we need more? So on my panel, I have, first of all, Mr. Neil Hines. He's the CEO of the Caribbean site for Forensics 360. He has a lot of experience working in forensics and other areas, doing training and other things across the Caribbean. We have Joyanne Goddard Griffith. She is the new head of the cybersecurity unit at the Ministry of Innovation, Science and Smart Technologies. So she would have a good idea of what the government is doing in terms of the cybersecurity. And we also have Mr. Dion Olton. He's a senior ICT cybersecurity consultant from the Caribbean Cybersecurity Center. And he also has a wealth of experience in Barbados and the wider Caribbean in the area of cybersecurity. So I'd like to start off by asking each of the panelists to give a few minutes their ideas on the topic of securing Barbados' digital infrastructure. The Data Protection Act is not enough. I will start with ladies first, so I would ask Joyanne to give a few comments on the topic.
Good morning again to everyone. It's good to be here. And just on the side, I just want you to know October 2 is also Cyber Security Awareness Month. So I'm very glad that we're going down here because it's going to be informing persons about the Data Protection Act, and it's not only enough. As you can see, the government is moving forward, whereby they have already, I would say, proclaimed?
Yeah, not proclaimed.
It's not proclaimed. It's passed, the Data Protection Act. And there are many key points within it. As we go into our discussion, we will speak about it. But I want to highly emphasize that, yes, even though the Act is there, it is not enough for us as individuals to just say, okay, the legislation is there. Much of it lies on us, the individual, because the data actually belongs to us. And we need to remember that we have responsibilities where our information is concerned. So I'm just putting that out there. I'll let Dion continue.
Thank you, Joanne. So, I know a lot has been said before about the Data Protection Act, and I think it's moving us in the right direction, and it's really a call to action for Barbados, for the Barbados government, for the Barbados citizens, and for Barbadian companies on the whole. It is a good starting point. When we say it's not enough, I would like to also challenge that idea, because you can't have an act and not have adequate implementation of the act. One of the most important aspects of the act is the enforcement of it, the implementation of it, and the education of the public to what the conditions or the bounds of the act represent, right? So when we look at the digital future of Barbados, where does the act fit? How does the act help us to protect the assets of the citizenry, the national security, public safety, and economic development of this country, right? And it is not enough, but I think is a brilliant start. I commend the Barbados government for moving in that direction. It's long in coming. And the act, I think, you need to understand the simple principles, not to overstate what was said before. The act has some simple principles. And one of these simple principles you need to understand, it forces the processors and custodian of our data to protect it. right? If we get this right, this can be transformational for Barbados. But we need to get it right. So one of the things that hinge on us getting it right is for government to choose or appoint the right person as the data commissioner. So if you get some person that does not understand the Act, does not understand the protection of our assets, then we're going to continue to meander. So from that perspective, the Act is not enough. The constructs of the Act will guide us down a road where, we're not meandering. Right now, I think, as it probably was said before, there are organizations in Barbados that have probably Windows XP systems hosting critical, sensitive information that belongs to the public, right? And those are areas of risk. Those are areas of significant risk when you drill down and look at the technical side of things. But what this Act does, and the powers that are given to the data commissioner, allows the data commissioner to stipulate categorically in the Gazette what the areas of controls that need to be implemented across the board. So that's why I say the Act on its own is not enough. The data commissioner is going to be the most important person and the caliber of that person, because that is how we are going to start to get the transformational change in the protection of the data assets of this island. And I'll stop there. For now.
Thank you, Dion. All right, now Neil, if you can give a few comments on your idea of the Data Protection Act not being sufficient to protect Barbados.
Good morning to all. Thanks to be here. Why is it not enough is simply because the public in general do not really understand the parameters and the dangers that exist against them. So we need also to go further than just the Act by doing a full-blown education program for the general public, as well as for companies to understand where they're going, where we are going as a country with this digital transformation. Because our data is valuable, our data belongs to us and not the government or not the hackers that are going to seek to get that information. We have the dark web. A lot of persons may not understand the runnings of the dark web, but the dark web is where all this information is being sold. So you could be sitting down in Barbados, never travel to Europe, but all of a sudden your information is in Europe committing crime. And where does that leave you? That leaves you to the point where you have to spend time in a police station or with a lawyer trying to clean up your data that you never gave out. So these are the things that we as a public need to understand, and we need to delve further into it. We are buying smart devices, right? We are buying smart televisions. Do you understand the threats within those devices? It's good to say, hi Alexa, turn on my lights for me, I'm not coming home. Right? But do you understand that Alexa is Amazon is keeping all that information and doing what with it? Using the same AI that was talked about earlier, and using it against you. So we need to do it more of a broader scale of education, along with the other things with compliancy by companies and compliancy by you as a public as well. Because if you're not compliant to your own data, you're opening yourself to serious threats.
All right. There's some very good points came up there about the Act and how it helps. And I agree with the point that the implementation and how the actual Act moves from paper to real life, that's going to be critical. But I want to ask some questions now in terms of what the Act provides. Now, the Act focuses primarily on people's personal information, or name or demographic information, critical information about us that people shouldn't have, vital information. But I want to ask a question about other types of data. While the Act focuses on personal information, there's a lot of sensitive data that isn't personal, information that might be used. I would say in critical infrastructure, there's information, data being held by organizations like, say, Light and Power Water Authority, that their systems need to operate. It's not personal, but it's very critical. And if you mess with that data, you can shut down critical infrastructure.
Correct.
So
Yes.
what I'm asking, how do you see the Act protecting that sort of non-personal information, or if the act doesn't, what are other mechanisms that are needed to close those gaps to also protect that sensitive but non-personal information? And I'll start with Joyanne
Again.
again.
Okay, now I'm glad that you alluded to like the Water Authority and those businesses and so on, right? We have to have our infrastructure secure. And that is key. And within the Data Protection Act, it gives guidance towards it. So even if I'm with a little small business, as I get information about me or about another person, I have to have a way of securing that data. So firewalls, antivirus, those simple little things. So you have to have what I would say a security posture with
Right.
these businesses.
I think Joanne, that last thing that you said about security posture, I think that's it.
Yes.
I think the act, while it is focused on personal identifiable information and the protection of that, no company in their right minds are just going to protect only the personal data. It makes good sense to have an information security strategy for your organization, which covers also your personal identifiable information. So if you're in, let's say, law enforcement, and you have information on border patrols, then you also have information on the citizenry. The security fabric that you put in place in your organization should be all-encompassing, right?
Right.
I don't think the act is saying neglect any other sensitive information. It says this is a call to action for Barbados and owners, and trust me, every single business on these shores has personal identifiable information, every single one. Now, whether you trade in finance or insurance or law enforcement, you still have to protect, the borders of your environment. You need to have a firewall. You need to make sure you have encryption. You need to put certain things in place. You need to guarantee the confidentiality, integrity, and availability of your information system. That is where the act takes us. I think it takes a big look at data and not only personal identifiable information.
Okay.
To add on to that, we have to look at the Computer Misuse Act. I think David was relating to the fact that these critical infrastructures have systems in place where they can turn off, a hacker can get in and turn off the electricity for a whole entire nation.
Yeah.
So within the Computer Misuse Act, you have the availability within that act, which needs to be, what's the word I'm looking for? It needs to be extended some more within the act, where a hacker can go into the act by using a simple script, and turn off the entire electricity for the entire island. That in itself can be prosecutable under the Computer Misuse Act. However, a lot of companies do not only put the firewalls in place and the antivirus systems in place. They do not have the persons who are monitoring that network for scripts coming into that network. Because an insider, which was alluded to earlier with the other panel, it could be a disgruntled employee.
Yes.
And the disgruntled employee was just reprimanded or something, lost $1,500, his salary to that effect, and he wants to get back at that company. He can use his information, his access, literally to cause that hack to be executed and shut down the entire plant for that particular business. So within the Computer Misuse Act, employees also need to understand that act, not only the Data Protection Act, but also the Computer Misuse Act, so that if something happens within, don't only take the internal action, but have it go externally to law enforcement, so law enforcement can also get involved and do the prosecution of that person.
Okay.
I just want to add to what you would have said, right? And that is why most businesses, I do hope, would understand why we need to have roles where we have different roles within the security administration within the company, right? So those things are critical within, where you have to have your protection within and then the protection without.
Okay.
David.
All right. Now, a previous panel was discussing breaches, which is a serious thing. Breaches happen all the time. But the legislation, prior to the Data Protection Act, there was no requirement to disclose if someone got in your system and stole information. I believe under the current act, if personal information, which is what the act really is focusing on, if that is stolen, there's a requirement for you to disclose that. That's what the act says.
Yeah.
Well, the question is, how do we deal with information that might not be personal? Okay, suppose I am an entrepreneur. I have intellectual property and I am using a service provider. I have this big plan that's going to bring me $5 million in the next 2 years. My service provider has my information, but it is not personal information. It is sensitive and it's very important to me. It's my intellectual property, it's worth a lot. How do the act deal with that? 'Cause, I mean, for example, if someone broke into my service provider and stole engineering plans for this great project I'm going to bring out, it's not personal information. The act does not require it to be disclosed. So how would we address that gap?
I think if you, and I've spent some time looking at the Act, if you look at the Act, it does not identify categorically what is personal data. So it gives the Act some latitude in associating what your personal data is. It could be your name, your ID number. It could be your intellectual property, right? There's also personal data. Your intellectual property is your personal data, right?
It's your property, but it's not considered because it's not about you as a living human being.
But the Act does not. The Act does not say categorically that those are outside the bounds of the Act. The Act is wide in the definition of what personal data is. So that is my personal data. I created it. I constructed it. There's my personal data.
I say
right?
that's your property.
So it's my property as well. Just as my name and my date of birth and all those things are. They're my property. So the Act the Act, based on how it's constructed, ensures that all the personal data that belongs to an individual must be protected. Whether it is, as I said, the Act does not identify what personal data is left to the interpretation, and it isn't perfect. It's a good starting point. Maybe version 2 of the Act will say it might include, intellectual property, right? But there are also other laws that will come into being for the misuse of because this one Act cannot cover everything under the sun. Okay. It's a good starting point.
The gentleman there think he may want to make an intervention.
Before we go to the question, we need to understand what is data.
Correct.
Data is information. Information is anything at all, tangible or non-tangible. It is your information. So in connection with what you were saying, trade secret is data, right?
Yeah, but
vital statistics is data.
Right.
All right. Me moving from point A to point B is data.
Mm-hmm.
And that's information because that's information that belongs to me in a sense because I'm saying I'm going from point A to point B. Mm-hmm. So it does not really matter or does not really, signify it must be vital data, vital statistic data for the Act. Mm-hmm. So anything at all that you create, even in a document, it is data, it is information. And that's where we need to understand that data is information.
Right. I would agree data is information, but I mean, at the same time, when we talk about acts, we talk about legal definitions, we talk about things that can't stand up within a court of law. So we have to be very careful about a layman's definition versus a legal definition. Because if something happened, someone will call their lawyer and say, "Are you liable? Did this person break the law?" So there's certain things that we might use as laymen, but a lawyer will look at things precise and will quote the letter of the law.
Yes.
Yeah. If you could
I'm
make
actually struck by the conversation, the discussion, debate, whatever you want to term it, that is going on there right now. I mean, I had a comment, but that discussion actually feeds into my comment because you have a piece of legislation that is about 100 pages. I started to look at it and my eyes just glazed over. And yet still, there does not seem to be clarity among you guys as to what the law says, what it means. I think, and I'm speaking now as an attorney,
right.
the legislation ought to be very narrow and very specific and tailored for the intended purposes. The danger that you get when you have it overly broad is that it makes it hard to understand, but it makes it even harder to enforce.
He wants it prescriptive.
And to prosecute. And if you have a piece of legislation where you can't prosecute, then you really don't have legislation to begin with or effective legislation.
Yeah.
If you
Go
so
ahead.
my take on that is if you look at the Computer Misuse Act, the Computer Misuse Act speaks to, let's take a clause that speaks to child pornography. It says, if anyone is caught with child pornography on a computing device, right? And it uses that broad term. This act does the same thing. It uses broad terms. So a computing device could be your computer at home, could be an iPad, could be a Surface, could be your
Server.
phone, right?
Your server.
So I think is deliberately broad to ensure
encompass.
that it encompasses the lot.
I hear you, and full disclosure, I'm not licensed here, so I'm not, whatever I say here is
Will not be held against you.
advice. A couple of years ago, I was involved in a cyberbullying project for local initiative here, looking at some of the legal aspects, and I did look at the Computer Misuse Act. I think, for just my personal opinion, it's a bad piece of legislation because it tried to cover everything but the kitchen sink, right? I don't know how many cases have actually been prosecuted under that law, whether it's actually effective or not. And some of the things in there, I think, don't necessarily make sense, right? Yes, I agree with you that law has to be broad in the sense that it has to be able to anticipate. I mean, from the very beginning, law always struggles to catch up with technology. It can never fully predict technology. You look at copyright patents and stuff, it's always having to be revised. It can be somewhat broad, but it cannot be overly broad because on its face, any law that is overly broad, not necessarily in Barbados, but in the US, it is considered unconstitutional because whatever law you come up with, it has to be understood. You can't pass a law where the people who are ruled by that law don't understand it, or the people who have to prosecute it don't understand it.
So let me just be devil's advocate here and use you as since you're a lawyer, right? If I created a patent, right? Is that considered?
If you obtained a patent.
If I obtained a patent, would that patent be considered my personal data? Would that be considered my personal data?
A patent is an asset. It's not necessarily data per se because the interesting thing about patent, I think, is sometimes misunderstood, is that a patent does not give you the right to do anything with the invention. It gives you the right to stop other people from utilizing the invention unless you happen to license it to them.
So it's owned by me?
It is owned by you. The invention, for a period of time, a limited period of time, the invention is owned by you. But part of the deal with a patent is that you have to give full disclosure, right? So everybody gets access to the information as you file the patent, but you own it for if the current term now is 20 years, for 20 years you have full control of the patent. But it is not personal data. if that's really what your question is, it is not considered personal data to you. Personal data is something in the realm of unique to the person. If you speak in terms of like medical personal data under like HIPAA, for example, what's called PHI, personal health information, it is those specific characteristics that allows me to identify a person for the purposes of recognizing who that person is. If I came in here and I only had a name, sorry, if I only had the name of a person, I could not pick out the name of the individual just by the name. So a name in itself is not simply personal data for privacy component. But if I knew a name and I knew what color shirt you were wearing, I knew the height, I could put those two pieces together and perhaps pick the person out.
Okay.
That's personal.
Right, that's personal.
That's personal.
But the pattern or the information within the pattern is data, correct?
It is data in a loose sense, but it wouldn't
But-
be considered data for what this law covers.
Not for the law, for personal data within the law. But I can't remember off the top of my head, but there's a definition for, I think, data, and there's also a definition for personal data or information, something like that. I could be wrong. But there is definitions within the law as to what it signifies, what each aspect signifies in a sense. So that is something that we as citizens also have to educate ourselves. Just don't look at the sections within the law and decide, okay, we're reading section 12, subsection 1, 2A that applies to specific purpose. Look and see what the definitions are for when you're reading the sections within the law.
Okay. All right. Thank you. So it's good to have a legal mind when you're speaking about acts and that sort of thing. Now, in terms of the act, what are your views? This to the panel. What role does the private sector or private sector associates have in terms of securing the infrastructure? As we said, the law cannot do everything. Do you see a role for the private sector or private sector associations in helping to secure Barbados, given the law being passed?
Yes,
Yes.
they do have sorry.
Go ahead.
They do have a role, and the role is simply this. First, create policies within your companies and your businesses. So the policies that you should look at is acceptable use of policy, because we have persons who are sitting down behind the computers taking selfies, and in the background of the selfies, there's vital information belonging to the business.
Correct.
And then you're posting that information on the internet, on social media, and it's out there for everybody to view. So the first thing is accessible use of policy for businesses, in addition to the firewalls and the network security protocols. The second thing is compliance for those policies. So if you create an accessible use policy, a Wi-Fi use policy, etc., you have to ensure that within your HR procedures, you have parameters that if you breach one of these policies, you are either suspended or you're paid something to that effect.
There's a consequence.
There's a consequence to it. And that way, we would get persons from not doing the things that they should not do was at work.
Okay.
If I might add to what you would have said, it's also the responsibility. Yes, they're supposed to have the user-accepted policy within the business, but it's also the responsibility to have the business when they join the business or become a part of the business that they are trained, they are educated, they are made aware, right? And even as time progresses, they need to have retraining.
Yes.
Right. And over time, yeah.
Yes.
Especially as things change, you need that constant.
And it's best to front load all of this now than to wait till the proclamation of the act, and then you have the data protection officer,
Yeah.
the chief,
Come
come
in.
in and say you are not doing
violating.
X, Y, and Z, and you're in violation. That way, you're going to be spending more money than if you spend $1,000 and save yourself
right.
$1 million down the road. So it's best for knowing where government is going to put these things in place before the proclamation of the act. I beg, I am pleading, there are things that they're easy. It is very easy, very, very easy for businesses to do now. There are online platforms, and there's Dion that's here that has numerous training in that regard. I also have. So front load no, than wait to spend $1,000, $2,000 in court.
Okay, thank. No, we only have a few more minutes, so there are two questions. I'll let this lady go first. She was first.
Lisa Evanson. My question to the panel regarding implementation. As a basis, are you aware that if Facebook tells you that you are not recognized, that they ask you to submit government-issued ID to get back into your Facebook account? You're aware of that? Okay. So I don't know who asked the government of Barbados, from Facebook, asked the government of Barbados, hey, can I collect the government-issued ID of Barbadians to let them back into their Facebook account? As a country of 280,000 people, what teeth do we have in this legislation to ask Facebook, why are you keeping the information of Barbadians? Did you ask anybody from the government of Barbados to hold government of Barbados ID? Because it asks for two forms of government issued ID, or it asks for your library card, and various other forms of subsidiary ID. So people trying to get back in their Facebook have their Massey card, their library card, their UE alumni card, their UE student card, and they've given it to Facebook. And Facebook's been breached. I don't know how many times since 2005.
Numerous things.
Yeah, that's a good question. Who'll take this first?
Let me start first by saying you have the responsibility to either A, continue using Facebook and give them your information, or B, just shut down that account, and if you must use Facebook for your business, create a different account. It makes no sense you putting your data out there and then it's liable to be hacked by some unknown entity. So if they're asking for,
or a known
entity. True. So if they're asking for your government issue ID, don't give them it.
And that is the reason why, in the other previous discussion, I am constantly re-emphasizing, I want the public to be aware of what's going on. You need to be educated. You need to know what is going on out there. Facebook is full of social profiling, as you know. Yes. As soon as you go on Facebook and you look at this and you look at that, next thing you see all these ads coming to you concerning various things. So you have to be aware of what's going on so that you understand, as Neil would have alluded, if they're asking you for that information out there, why would you want to put it back on Facebook, right? As he says, shut it down, use a different account. You need to make educated decisions as individuals. That will be the key for you as your data and privacy. That's what I want to put out there for everybody.
Okay. All right. You have a question?
Well, a comment from the previous discussion you were having with regards to data, personal data, and the definition in the Act. So the Act actually does define both data, generic data, and personal data as well. And the Act it says it's specific to personal data. So when you made a comment about non-personal data, if there's anything to cover that, I think that's a valid point that you made.
Okay, thank you. All right. I'd like if y'all could do a wrap up, basically in terms of a summary of where you see we are in terms of the act and how we go forward to make up for any deficiencies of the app.
Okay, as my fellow panelists would have said, the act is the beginning. Okay, it's a good direction where government has, put out there. It is the beginning. It's important for businesses to be aware of what is within the act and to try to become compliant with the act. So you have to understand your role, you have to understand your responsibilities. And again, individuals, I want you to be aware of your role too, your responsibility and your right under this act. And that's all I just want to keep putting out there for you.
I think when you look at securing an environment, the act is a minute part of it. There are several things within that ecosystem, right? The act is a part of government's responsibility to help protect themselves and help protect the citizenry. And the part of the citizenry, obviously, are the businesses within this island. I see the act as a call to action. It essentially says these are the terms and conditions under which you need to protect yourself. Now, one thing that we haven't, I'm not sure if it was mentioned in the previous session, but one thing that the proper implementation of this act will do is give the commissioner, I think, the right powers, because the commissioner in his office
What
can.
commissioner you talking about? The data.
The data
The
commissioner.
data commissioner.
Yeah, the data commissioner. In his office, he has the power to seek a warrant from a high court judge if he thinks he has proven to the judge that you in your office has data and you're not protecting it adequately. He can seek a high court order, right, a warrant to enter any organization with his team, and it's going to be like CSI style, right? You have to step back from your computer. He can go in, gather any information, and we don't want to go there. So the act, again, call to action, we need to get our house in order. Just like last year with GDPR. GDPR wasn't anything new. GDPR was just a beacon for all organizations that said we need to get our houses in order. I think that's what we need to focus on, right? And within that whole ecosystem of being IT secure and IT aware and cyber resilience, right? There's several different components. Most of them the act doesn't speak to, but that doesn't mean that you don't have to get your house in order. So the responsibility is on us, the data subjects, to ensure we don't share information in the wrong place, and that we know that we have powers. We can go to an organization that has our data and ask them how well is it being protected. The data commissioner in his job can seek, if you have recourse, you can go to the data commissioner and say, hey, I think that this company over here is not protecting my data adequately, right? So it will force organizations who have our data to protect it adequately. And no person in their right mind, if there's a CEO, CIO, any business manager out there, is only going to focus on protecting the business, the personal identifiable data. It makes no sense. They're going to protect their entire environment, proper firewalling, antivirus, get rid of obsolete software.
Correct.
User training. User training is one of the greatest assets, or one of the greatest ways you can transform an organization, by teaching your end users not to click on links, not to open files that might be from unsolicited sources, right? Having proper policies. Neil mentioned this. Having proper policies in place. There's so many things, but the Data Protection Act is the beacon that says, now, we're going to put a commissioner in place. We're going to come and check your organization, and you have to comply. We can go to High Court judge, and we can enter your organization, and if you're in violation of the conditions, then you get fined. And some of the fines are as stiff as $500,000, right? I think nobody wants to go there.
I think we got a question before you wrap up.
Oh, yeah, you have a question or comment, sir? Yeah.
This thing working? That's the first question. Second
Yeah.
question. With respect to the legal liabilities that companies have to protect your data, banks, for example, insurance companies, medical facilities, does the Data Protection Act make it incumbent on them, or are there other acts that require companies to take the necessary measures to properly secure your data? and you find, for example, they are not, or the data commissioner finds they're not keeping your data securely, and some harm has come to you as a result, or your business as a result, can somebody speak to whether there is any room for discussion on that in the Act, or has there been?
So you're asking about like banks, organizations, like a bank, if such organization fails to protect your data, if there's something in place to give you.
Yeah, it doesn't have to be a bank. It could be Massey. It could be, you know, I buy a car from somebody and I'm financing it, and you know, I give them all my data. It could be, you know, and any company that has my credit card data, for example.
All right.
Within the Data Protection Act, that covers not only PIA information, it covers all information that company is gathering about you or the business in general. So there are parameters within the Act that can address and will address the security infrastructure and the requirements that businesses must put these security infrastructures to protect the data. So it is not only telling businesses that who are collecting this data, they're actually dictating that you're collecting it, you're processing it, you're storing it, you're responsible for the protection of it in all parameters. In addition, if you're having a third party store that information for you, the business who will hire that third party has to ensure or put things in place to ensure that that third party is protecting that data. So don't think that the business is going to get away by telling, let's say Massey develops a server to hold data for the entire Barbados business community, that those business community members don't have to ensure that Massey is ensuring that protection is in place. So there are two levels there. There's the business community that have to ensure that the third party application is doing all they need to do to secure that data. And that is covered on the Data Protection Act.
Yeah. I believe that third-party entity, whoever they are, they have to be at the standard to comply with the Data Protection Act.
And the Act also speaks to not just the technical competency and ability for the organization to protect the data, but also the organizational measures that the processor need to have in place. Mm-hmm. So training of your end users, you know, simple things like having a clear desk policy, not walking away and leaving customer information at the front desk that is printed and leaving the customer there, you know, so that it can walk through the door, you know, stuff like that. I think the Act intentionally is written to be wide, but then once the commissioner comes into office and we get a good commissioner, we're going to see it is going to be a lot more granular, and you're going to see a lot of things are going to be called to action. You're going to see a big change in this place.
All right. Now, in terms of GDPR, when the European Union enforced their act, and our act tries to manage that act, they would have implemented that on May 24th last year. Now, their act would have been passed 2 years prior. So the world had been, because the GDPR extends to the entire world, not just the European Union. Mm-hmm. The world was given 2 years to prepare for the GDPR. In terms of that time, no, we're in a similar position where we've now passed the act. So we don't know when it will be proclaimed, but we have time. I'd just like the panel to give some concrete recommendations for what we should be doing while waiting for the proclamation of the act, so that by the time it comes and it says it's proclaimed, we are ready, and you know, as opposed to being the scrambling.
I think the first thing you should do is read the Act. You need to understand it. You need to understand what the Act says, how it impacts on your organization, and the things that you can do now. The Act speaks about encryption of personal data. It speaks to the ability for your organization to recover from an incident. It speaks to your organization's ability to store the data in a secure form and only use it for the purpose for which it's intended, for the time you're supposed to have it. There's certain things that you can put in place right now based on the act. So I wouldn't say wait till next year if it gets the rubber stamp next year to do these things. These are things we should have been doing, 5 years ago.
Year one.
Right?
Go ahead, Neil.
In addition to that, train.
Yes.
Put training in your budget. So if you're only budgeting to buy $10,000 in merchandise to sell to make $20,000, put an extra $10,000 to train your staff. So you have to look at training, read the act first, as Dion said, comply with the parameters within the act, train your personnel, get policies in place, implement them, and also enforce them before the proclamation of the act. And those things, once you have them in writing and something happened to your data, you have ensured that you have put these certain parameters in place to help protect that data. And you would not more likely not get fined. Cannot say it for sure, but at least you have documentation for those parameters to secure your network and secure that data.
Also, don't be afraid to ask for assistance or help.
It's true.
I think that is what you have to realize as well. The act is passed, but it will be implemented. In other words, there's going to come to a point where you don't have any more leeway, and yes, somebody is going to be knocking on your door, investigating how you are treating data. So now that you are aware, as the others would have said, you read, you educate yourself. For sure, the government will have education, seminars, and so on, try to make you be aware of what your right and responsibility is. But besides that, if you know you don't have the technical know-how in-house, solicit it. There are companies here who can assist you and ask for the assistance so that when everything is ready to go, you will be in compliance.
All right, see this gentleman here, he wants to make a question or comment.
Yes, good morning. It's more of a question, really, and I will confess that I haven't read the act, so forgive that. I'm wondering, are there any explicit prohibitions within the act with respect to how companies treat to data
The data of children?
minors? Yeah.
Children, minors.
There are parameters within that act, and there also goes back to the Computer Misuse Act. So if certain things are not covered within the Data Protection Act when it treats the minors, like their vital statistics or health records, etc., it can go back into you can revert back to the Computer Misuse Act, which can assist in that regard. But there are parameters within the Data Protection Act when it speaks to minors.
Yes, sir.
The lawyer.
What you just said in terms of GDPR applying to the entire world.
Yeah.
It is trans-border to the extent that you're dealing with the data of an EU citizen.
Right.
Yes.
If you're not, then it doesn't. And the same thing would apply
Yeah,
to
yeah,
Barbados.
that's quite correct. That's why, yeah.
One comment I'd like to make is that it's wonderful that we're digitizing and looking at the legislation to go along with it. But the other component that you also have to pay attention to is on the judicial side, you also have to develop standards for electronic evidence, right? Mm-hmm. And because you're dealing with, if these matters ever get to court, you will essentially be dealing with electronic evidence.
Yeah.
And you can't assume that the same way that you can walk into court with a paper document like a contract and be able to authenticate it, that you can do the same thing with something in electronic form, hand the court a disc and says,
correct.
This is proof of the matter. You have to develop standards from the court side as to how you handle electronic evidence, and I'm not sure that we've actually done that or even paying attention to that aspect.
Don't say that we're not paying attention.
No,
It's just that the
he said he's not sure.
legislation.
He said he's
I
not
said I'm not
sure.
sure.
Yeah.
Right, it's just that the legislation, all of that is in the works because it is going to change the whole landscape. So yes, you will be looking at digital evidence.
So here's the thing, though. I'm not sure that you can be passing legislation right now.
So sorry to cross you, sir. On a point of clarification, right? We have certified forensic practitioners in the room right now who are trained in data acquisition, chain of custody, and also have been able to present cases in the court of law in Barbados and across the region. In this room right now, I can identify Francois Griffith right there. Francois, he can talk to you offline, but we have those resources here on island. So if it comes to the point where the data commissioner needed a resource to capture evidence, present it in the court of law, we have skilled team members that are here that can.
I wasn't referring to the collection of the data, the capturing, or the talent pool there. What I'm saying is that there are rules of evidence that applies in court, right? You just don't get to walk in and say, this happened because I said it happened, or because I can show a picture. They're formal rules of evidence.
Yes, and we follow all those. That's all I'm saying.
And the judicial as well are trained. We have provided training to the judicial. We have provided training to law enforcement. So there are that law enforcement, trust me, and the judges already receive digital evidence, electronic evidence in court, and it was successful prosecution. So from that regard, yes, we are in the right direction for that.
Okay, thanks. Yes, you want to make a comment? This lady here first, please.
Hello, I'm
Hi.
Joanne Hayes from Massey Technologies, and we are one of the helpers in the industry when it comes to security, fabric and security solutions. Just want to put that out there. Just saying.
We'll send the bill later.
Okay. No, one of the things that always bother me is how do you police something that's borderless? Whose laws rule? And as a small spot in the world, do we have the muscle to fight with the U.S. or wherever, like Neil said, that their data ends up in Russia? Or are we at the table and represented that we have a voice, or that we have laws that protect us too?
Yes.
If we do, it needs to be said, published, whatever you want, shared. Okay?
That's a very good question.
Just to answer that question for you, there are legal procedures in place. So once you report a matter to the police and it is in another border, the Director of Public Prosecutions is mandated to write to the particular country. So if you're talking about the U.S., there are personnel within the embassy here, the U.S. Embassy, that a legal document goes to that department within the embassy, and an active investigation is commenced on the U.S. side to assist with the Barbados leg of the investigation. So there are laws to help with that regard, and then there are also procedures that goes through the Director of Public Prosecutions.
And the other, well, I have a lot of things to say, but I'll only say to summarize what's going on in my head. The other thing that I'm thinking is we need cyber lawyers and we need a cyber court. I would hate to think that I'm caught up in the criminal system, waiting on something that's to do with a cyber issue, because it could be even worse than what's on the criminal side. So I think that's something that we need to advocate for, and to train our lawyers in the direction of also being cyber lawyers as well.
Okay.
That is true, and let me just wrap it quick for you. This is why we need the public and the universities and the Ministry of Education to come aboard and create that niche for our public, because there are only certain amount here in the Caribbean. So we need to get persons more involved. and academia.
All right, we have time for one very quick question. Let's hope it's easy.
I'm not sure. It was just to follow up from the previous question with minors. I know we have 3-year-olds on the internet these days, but as I understood it, most of the time they fall under their parents. So, you know, like a minor can't really create a Facebook account. They have to lie
Right.
about their age essentially and put that change their date of birth. So I would be interested to see how the law would treat something along those lines, especially if you might have schools with their information online, but those would probably fall under the school rather than the individual.
And this is where we need to get education and responsibility of parents and public in general. You're the parent, you know what the parameters are. Don't go there and put your child out on Facebook or on social media. To me, you're creating a whole different lane of havoc and threats to yourself.
All right. Well, we're out of time. I'd like to thank the panel. I'd like to also thank the audience, especially the questions and comments. So just like to thank you for bearing with us. And I believe we probably have lunch coming up sometime soon. So just wish that you enjoy the rest of the Smart Barbados Week. Thank you very much.
There was so much.